On 13th March 2015, the then Finance Minister was presenting budget in Kerala Legislative Assembly. At that time, the accused were members of Legislative Assembly. They disturbed the presentation of budget, climbed over to the Speaker's dais and damaged furniture and articles including Speaker's chair, computer, milk, mic, emergency lamp and electronic panel, causing a loss of rupees 2,20,093. The incident was reported to Museum Police Station by Legislative Secretary. While the freedoms protected by both limbs are substantively same, the second limb is clarifactory in the sense that it prevents any person from initiating proceedings in the House when they obtain knowledge of exercise of said freedom through a publication. On completion of investigation, the cognizance was taken by additional CJM of the said offences. The events transpired during a session of Legislative Assembly when certain MLAs protested against budget presentation. The protest by MLAs is protected by immunities and privileges provided to them under Article 194(3) of Constitution of India. A violation of rights and immunities granted to MLAs is a breach of privilege, and Legislative Assembly is empowered to punish such actions which are offences against its authority and of disobedience of its legitimate commands. A breach of privilege is contempt of House, which falls under the exclusive jurisdiction of Speaker of Assembly. An offence which is committed in Assembly during a session or in its vicinity by MLAs cannot be registered by police without permission of Speaker. Police officers requires authorization from competent authority to investigate a breach of law if it occurs in the precedence of Legislative Assembly. The freedoms granted to MLAs are necessary for functioning of democracy and are subject to the powers of Speaker or criminal courts with the sanction of Speaker. The continuance of the trial of MLAs in absence of sanction of Speaker lowers the dignity of Assembly amongst citizens, thereby affecting public interest. According to the charge sheet, the incident occurred during a protest by the party in opposition against the presentation of the budget. Thus, it is difficult to access the rules of the offence. The statements of witnesses are vague and there is an absence of proper identification of persons involved and their participation in the commission of alleged offence. Investigating officer has failed to record the statement of natural eyewitnesses, that is, the MLAs who were present in the assembly. This casts a doubt on the nature of investigation conducted. It indicates that the prosecution has a remote chance to prove its case. A copy of video recording of incident was procured from electronic control room of Legislative Assembly without the sanction of Speaker. The video footage lacks certification and the admissibility of this evidence would be under challenge in the trial and the property owned by government of Kerala was destroyed. Government had consented to the withdrawal of prosecution and hence the large public interest would be served if the case is withdrawn early. However, it is erroneous to suggest that the loss of public property is a loss occurring to government. Damage to public property causes a loss to the public exchequer. The alleged offences are of a serious nature and the role of court is to assess that whether the application is made in good faith in the interest of justice and public policy and not to stifle the process of law. The application of prosecutor fails to inform the court that how the withdrawal of prosecution in the case would achieve these objectives. Thus, it is presumed that the application is filed without good faith and is based on external influence. Stop.